focusing on access in particular, which is part of the broader range of media law, access is critical if we're to understand how our institutions of government work. And I think the revelations of the past 2 or 3 years, with the knowledge we now have about surveillance and the way technology is being used, has made this even more critical. It's quite clear that new technologies and the way the government is using them have fundamentally altered the relationship between the government and the people who are governed. There's been a huge power shift. Never before in our history has government had the ability to know anything that anybody's saying at any time and been willing to exercise that ability. So it's just critical that we use the tools we have as citizens to know what the government is up to and to be able to exercise oversight. And we've seen the importance of that in the post 9/11 world, where there's been an increasing move towards secrecy and just an urgent need for news organizations and individuals to assert their rights to demand information from the government. So access has been a common thread. In recent years, particularly since 9/11, there's been a shift in the focus of my private practice, to deal much more with national security related issues and leaks investigations of reporters. So there's been a huge focus on the reporter's privilege. I represented the Associated Press a couple of years ago when the government seized a lot of their phone records and working out the rights of that. I had an opportunity to advise when WikiLeaks came out, a couple of clients about how that should handle, and that led to the opportunity I've had to represent the Guardian and Glenn Greenwald in the Edward Snowden disclosure issues. So it's been a really fascinating time in dealing with press issues and the government. The clinic was founded in 2009 by a group of 4 Yale Law students who, working with Professor Jack Balkin, came to realize that there was really a compelling need for legal services to be provided to journalists and reporters of various sorts, as there was this massive change happening in the industry. Newspapers were having financial troubles, reporters were being laid off. And increasingly, there was kind of an entrepreneurial press, people doing startups online. And this led to 2 key issues that the clinic was intended to address. One is that these journalists who now were no longer affiliated with large institutions didn't have access to the type of legal services they needed if they were going to be effective at investigative reporting. So there just was kind of a typical legal service need for people who couldn't really afford lawyers. And the second was that as these journalists were moving online, there are significant issues and concerns about how we translate the First Amendment principles that have been established in the print world, the rule against prior restraints, the standards for defamation, the rights of access, reporters' privilege questions, how all those legal doctrines get translated into a digital world, and concern that a judge might consider the First Amendment issues differently when they're dealing with an individual working out of their home office than they would if they were dealing with a New York Times reporter. So there's a major effort at focusing on how to establish First Amendment doctrines in a digital era that accomplish the goals of the First Amendment. The work of the clinic today is focused really, I guess, into 3 different areas primarily. One is just generally developing access theory and the constitutional right of access. The clinic has done that in a number of ways over the years. Some of the early clinic cases, one was a case in New York called Moslem, which represented an online journalist who was unable to get access to summary judgment records that were sitting in a judge's chambers in New York court. And it went on for like 2 years, and it was a case he was interested in following. The clinic took the case because there was very little case law, believe it or not, in New York state courts about how the First Amendment right of access applies. New York courts typically view it as a a New York statutory right that has a fairly low standard of good cause under which you can seal a record. And so the clinic took this case and appealed the judge's actions to the Intermediate Appellate Court and got a very good ruling that the First Amendment right of access does apply. And that's still today one of just 2 cases at the appellate level in New York trying to define that. So that's one way. And there's been a number of other cases. There's a second focus, which is essentially on government operations and helping journalists who are having trouble getting information from the government in cases that will shed light on important government activities. So for example, the clinic represented Carol Rosenberg, a Miami Herald reporter who's one of the primary journalists covering what's going on at Guantanamo in litigation under the Federal Freedom of Information Act, where she was trying to compel the Department of Defense to identify the names of the detainees who were held at Guantanamo who fell into this category of detainees that the government had concluded it had no basis to hold or to charge criminally, and yet was not going to release because it thought they were too dangerous to release. So they're sort of in indefinite detention. And the government had made it known that they had made these determinations but wouldn't identify which of the detainees they were. So the clinic assisted Carol in getting that information. And then there's the third piece that's related to the first 2, but it's kind of specialized, which is the national security piece. And the clinic's done a number of significant things in the national security area. We're currently representing Nick Merrill, who is an individual who ran a small internet service provider very early on after the Patriot Act was passed, and he was served with an administrative subpoena by the FBI, but one that's known as a national security letter. And under the Patriot Act, the FBI had the authority to issue these subpoenas and include on them orders just from the FBI saying you're not allowed to tell anyone that you got this. And Nick Merrill litigated that with the assistance of the ACLU in a case that's now known as Doe versus Ashcroft, the constitutionality of that type of gag order. And the Second Circuit limited it substantially in terms of the scope of it, but he's still subject to a permanent gag. So he's now asked the clinic to return to court for him 10 or 12 years later to get this permanent gag lifted. Well, one of the really exciting things for me is the opportunity to work with Yale Law students. They are incredibly bright, highly motivated, and very creative. And so the work of the clinic in terms of thinking through legal theories, how the First Amendment doctrine is going to apply online, how we expand the right of access, it's just a font of wisdom, and it's just really motivating and exciting for me to have this opportunity. And the clinic in particular is a really needed resource. As I said earlier, the idea came from these students who recognized that there were these journalists without access to services. And fortunately, there are some funders, primarily the Knight Foundation and the Stanton Foundation, who recognize that this is a problem for our society as a whole. And they've looked to the clinic at Yale as a possible model that could be emulated in other regions of the country to provide the types of legal services that news organizations used to have the financial capacity to provide, but they're not doing today. So it's very exciting at a number of levels.